Though I am a professor of international relations, I seem to do a lot of episodes on the U.S. Supreme Court for this podcast. Some of that is because I have easier access to people who are willing and able to join me in the classroom to talk about the court, but probably a bigger part is how consequential the decisions of 9 people are for the 330 plus million residents of the United States. In a previous podcast, I spoke with Professor Evan McKenzie about several decisions that were released in June 2023. Today, I'm going to drill down on the 2 affirmative action cases, Students for Fair Admissions versus Harvard and versus the University of North Carolina, with my guest, UIC law professor Stephen Schwinn. We're not only going to talk about these cases, but also the history of affirmative action in higher education, the history and application of the Equal Protection Clause of the 14th Amendment, and how one justice in the 1970s set the standard that regulated the past 50 years of college admissions. One note before we start, somehow my recording settings were set to my headset mic and not the more professional mic I'm using now. Therefore, the audio quality on my end isn't great, especially because I'm not an audio engineer and couldn't perform magic during post-production. I hope you're able to put poor sound quality aside, because you're not going to want to miss this conversation. So let's get started in the Politics Classroom, recorded on September 15th, 2023. Welcome to the Politics Classroom, a podcast of UIC Radio. I'm Professor Kate Floros, a clinical associate professor of political science at the University of Illinois, Chicago. For more information about the topics covered today, don't forget to check out the bookshelf section of the podcast website, thepoliticsclassroom.org. I'm thrilled to welcome into the classroom today Professor Stephen Schwinn. Professor Schwinn received a bachelor's degree in humanities from Michigan State University and his JD at the American University in Washington, D.C. Prior to entering academia, Professor Schwinn worked as an attorney for the Peace Corps, as well as serving as a volunteer or pro bono lawyer in the nonprofit space. Before coming to Chicago, Professor Schwinn taught and directed clinics at George Washington Law School and the University of Maryland School of Law. He has been in Chicago for a decade at the John Marshall Law School, which was acquired by UIC in 2019 and is now the UIC School of Law. Professor Schwinn is also the co-founder and co-editor of the Constitutional Law Prof blog, and you can find the link in the bookshelf section of the podcast website, thepoliticsclassroom.org. Professor Stephen Schwinn, welcome to the Politics Classroom.
Thanks so much for having me, Kate. It's a pleasure to be here.
Well, I'm really excited to talk to you today about affirmative action. And so let's just jump right into the case that was decided in June of 2023, Students for Fair Admissions versus Harvard and versus the University of North Carolina. They were argued separately, but I believe that the decision is the same for both.
That's exactly right. There's a technical piece of this that one of the opinions relates to the Equal Protection Clause under the 14th Amendment. The other relates to Title VI of the Civil Rights Act, but we can talk more about that if that's relevant.
Okay. So my understanding of this case, or the decision, a 6-3 decision, struck down the admissions policies that used race as one factor among many, saying that such policies violate the Equal Protection Clause of the 14th Amendment by treating students differently based on their race. So I have 1.5 million questions, but let's start with the 14th Amendment. It was ratified in 1868. It is the second of the 3 so-called Reconstruction Amendments. The 13th abolished slavery, except as punishment for a crime. The 15th Amendment gave Black men the right to vote, and in the middle is the 14th Amendment. Section 1 of the 14th Amendment reads in part, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." And so the Supreme Court said in this case that using race in almost any part of the admissions process violates the Equal Protection Clause, presumably because it discriminates against white people. So did I get that right? And am I understanding the opinion correctly?
Yes, in general. Kate, I'm going to adjust just one thing that you said just a wee bit slightly.
Sure.
So what the court's saying is that the Equal Protection Clause prohibits racial labeling, period. Whether that inures to the benefit of white people or Black people or Asian people or Latinx people or whomever, it's the racial labeling that the court says the Equal Protection Clause is concerned about. That the racial labeling is the kind of constitutional evil that the Equal Protection Clause is designed to prevent. And in order to see that point, it might kind of help to rewind to 1954, if I could for a second.
Yes.
Talk about Brown versus Board of Education and talk about what I view as a kind of continuing struggle over the legacy of Brown versus Board of Education. So we'll remember, and listeners will remember, that Brown versus Board of Education struck the idea of separate but equal in public segregated schools. This idea, a legacy from Plessy versus Ferguson, that said separate but equal rail cars is not unconstitutional because, after all, they're equal. Well, fast forward to 1954. The genius of the litigants in the Brown case, and here we're thinking about the passionate, clever, creative, driven attorneys who brought the series of Brown cases, including Thurgood Marshall himself, that what they understood was that separate but equal can lead to disparate outcomes by race. That separate by equal facilities, when you filter that through the reality of structural racism, institutionalized oppression, those features of our society, that separate but equal leads to disparate outcome and inures to the disadvantage of Black people. So they litigated Brown versus Board of Education, and they were very careful to show that in school districts that by some facial measures of equality were actually separate but equal, that in those districts they nevertheless resulted in a disparate outcome, and that Black children got the short end of the stick. And so in that way, they could tee up a challenge directly to Plessy versus Ferguson, separate but equal, arguing that, look, we've got separate but equal in these school systems, and yet still they result in inequality. Now, when I tell the Brown story that way, we might think that the court in Brown versus Board of Education was concerned about the inequality in outcome. In other words, the Equal Protection Clause, according to this reckoning under Brown versus Board of Education, says that when the government adopts an action that results in an unequal outcome, that violates equal protection.
Okay.
And a lot of people think that and thought it. Well, fast forward to the Roberts Court. The direction that the Roberts Court has been moving is to interpret Brown versus Board of Education not as concerned about that disparate outcome, but rather as concerned about the disparate treatment in the first place. In other words, the disparate labeling that results in Black schools and white schools, as was the reality for Brown versus Board of Education. And what the Roberts Court has been moving toward is this idea that it's that racial labeling, that segregation in the first place that the Equal Protection Clause is concerned about, never mind the unequal outcome. What the court says is, we're not concerned about that. Brown isn't concerned about that. We're concerned about the racial labeling in the first place. Now, there's a kind of pithy way to summarize this that Chief Justice Roberts has used in a couple of cases, one involving school desegregation a decade or so ago, and then in this opinion this summer. What he wrote in the school desegregation case is, the way to stop discrimination by race is to stop discriminating by race. And in this opinion, what he said is, the Equal Protection Clause demands equal treatment for everybody. Equality means equality for everyone. And what he means by that is that the Equal Protection Clause protects both Black people, white people, Latinx people, whatever race or ethnicity. The Equal Protection Clause protects us from government labeling alone, irrespective of the outcome, irrespective of any disparities that might exist in society, it's simply not a part of the equation.
Okay. That just raised about 400
exactly.
additional questions. So, okay.
Take a minute with that, right?
Okay. So the argument in Brown was we have equality of this white school and this black school that we're using in this case, and yet we still have different outcomes in which the black students do worse, even if we can show that the schools are equal. And so because of this, segregation itself is problematic, and therefore we can't segregate. And somehow from there, the Roberts Court is saying we just can't talk about race, even if whatever institutions we have produce disparate outcomes.
Well said. I don't think I could have summarized it better. And what's so strange about that, in my thinking, is that it really turns Brown on its head. It really requires a different way of thinking about race discrimination in Brown versus Board of Education than many of us are accustomed to. It's problematic because it ignores institutionalized racism and systemic oppression. Those are not equal protection problems, according to this court. It's the racial labeling alone, and racial labeling, incidentally, Kate, for any purpose whatsoever, whether that's to benefit a group or to harm a group, or racial labeling for completely neutral purposes. Whatever's going on with government racial labeling, the court is going to find it suspect under the Equal Protection Clause.
So does that mean that things like hate crimes or enhancements, like judicial punishment enhancements, if race is involved, that those are all potentially in violation of the Equal Protection Clause?
Well, so things like that, so sentencing enhancements and hate crimes and the like have gotten a pass around the Equal Protection Clause so far. But it hadn't occurred to me, but as you mention it, those may next be on the chopping block with this court. This is a 6-3 conservative majority court that really is bent on solidifying, concretizing, and codifying this, what I consider to be a highly unusual view of anti-discrimination and equal protection. But this is where they're going. And with every passing decision on race discrimination, it seems that this idea becomes more entrenched in our jurisprudence.
Okay, so the other thing about conservative jurisprudence, as I understand it, is that we need to really rely on history to inform how things are supposed to be. So does anyone go back to the fact that the 14th Amendment was passed by radical Republicans in an effort to ensure that Southern states could not treat Black people horribly who were just coming out of enslavement? I mean, the whole point of the 13th, 14th, and 15th Amendment was to benefit Black people. Is that not at all part of the history that should be considered when interpreting the Equal Protection Clause?
Well, it's very much part of the history that should be considered in interpreting the clause according to the dissenters, Justice Sotomayor and Ketanji Brown Jackson in this case, and more broadly, Justice Kagan as well, will all sign on to the idea that the history that you just recited is exactly the correct history, and indeed most historians would too. The majority tells a slightly different story about that history. They hold themselves out as historians and give their own gloss on that history. What they say is the Reconstruction Amendments were designed, and in particular the 14th Amendment, was designed to ensure equal treatment among different people. And at least one justice in the majority, and maybe more, think that ideas like Reconstruction were not specifically designed to level the playing field for Black people, but rather to level the playing field for, and here I'm going to use a dated term, but it's a late 19th century term, freedmen. And what they say is freedmen is a race-neutral concept. Yeah.
How many white freedmen were there?
Yeah, well, I don't know, because you'd have to ask Justice Thomas that question, but because I'm not counting a lot. But that's where their head is, that this idea of serving and equalizing the playing field for freedmen was what Reconstruction was all about, and that's a race-neutral concept, and that underscores their revisionist history that the 14th Amendment and our Reconstruction history was really about equality of treatment, not equality of outcome. Now, if I can just add one beat to that, the historical record on this is just so crystal clear. And in fact, the very framers and founders of the 14th Amendment turned around and enacted the Civil Rights Act under their authority under the 14th Amendment to ban racial discrimination, even in places of what they called public accommodation, places like theaters and hotels and restaurants and that kind of thing. Now, what's notable about that is that tells you they themselves, the framers, were concerned about societal racism, institutionalized oppression. But we've moved 180 degrees away from that in our jurisprudence today. The irony here is that you're exactly right when you opened this part of the discussion and asked, aren't the conservatives concerned about history? They are, but in an opportunistic way. I think about this as opportunistic historical interpretation or opportunistic originalism, where they can kind of cherry pick and choose the sources that they look at and the way that they interpret it to come up with some really surprising interpretations. In this case, the affirmative action cases, Justice Ketanji Brown Jackson, in just a blazing, fiery dissent, it's a wonderful read, actually gets history right and closest to what the historians, in fact, right on with what the historians say about the history of the late 19th century.
Oh, this is why I study international relations, because it has its own insanity. But if I had to talk about Supreme Court cases all the time, I think my head would explode.
Oh, and we're only scratching the surface.
Let's take a quick break. This is Professor Floros in the Politics Classroom, a podcast of UIC Radio. This is Professor Floros in the Politics Classroom, a podcast of UIC Radio. I'm speaking today with Professor Stephen Schwinn, a professor at the UIC School of Law. So there's this idea of colorblindness, right? Of race neutrality. I can't imagine that even in the rarefied world in which the Supreme Court justices operate, that they actually believe that American society is colorblind and race neutral. And certainly at the time when the Constitution was written, certainly when these amendments were written, society was definitely not colorblind. So where does this notion of colorblindness and the Constitution being colorblind, what's the foundation for that when clearly it wasn't colorblind in its creation or amending? It's
a fantastic question. So it's, when you read the Equal Protection Clause in the 14th Amendment, it just says equal protection. And there are 100 different ways of thinking about equality and equity and how to achieve those. So this idea of a colorblind equality is certainly, everything else being equal, if we were in a sort of alien coming to Earth and saw equal protection, one plausible interpretation of that, one among 100 plausible interpretations, could be equal treatment. The history belies that. And so, what the conservatives on the court have done is really cherry picked from the history and given it their particular gloss to support this idea of colorblindedness and wrote that into the jurisprudence. And then I love this move. When they write it into the jurisprudence in one case, then they can cite it in subsequent cases because it's authoritative and it kind of snowballs in that way. But I'm going to try to be fair to at least some of the conservatives. I don't doubt that there are some on the bench who truly believe that we are a level, equal society and that they truly believe in their heart that equal treatment is achievable. But I also think that there are some on the conservative side who, as you said, even in their rarefied society, they've got some understanding that we don't live in an equal society. Trying to be fair to them, I think what they're probably saying is, look, we get that we don't live in an equal society. There are a lot of ways to achieve equality. One way would be to take account of race to achieve equality. We don't think that's right because we think taking account of race perpetuates the idea that government can take account of race for some reason, even if a laudable reason. And we don't want to perpetuate that. We want to erase race lines, root and branch, and eliminate this idea of racial labeling, racial tagging at the outset. And that leads to a colorblind constitution. And, there's a kind of logic to that. I disagree with it profoundly. But if I were pressed, I think that's where they're coming from.
Okay, so the term affirmative action came from a President John F. Kennedy executive order, EO 10925, which says that government contractors must, quote, take affirmative action to ensure that applicants are employed and that employees are treated during employment without regard to their race, creed, color, or national origin. So I'm sure there are a million challenges to affirmative action in employment. But there have also been a ton of higher education cases, or maybe not a ton, some very substantial higher education cases. Why is that? What is it about college admissions, university admissions that attracts this kind of scrutiny on policy?
Fantastic question. Can I take a second and just back up and contextualize affirmative action? So there are a lot of different ways of thinking about affirmative action in general. And what you quoted from President Kennedy was a view that really isn't what in constitutional law we would think of as race-based affirmative action, but instead equal opportunity, right? That you can't consider race. We're going to treat everybody sort of equally irrespective of race in employment opportunities and government contracting and the like. When we think about affirmative action, we can think about it two ways. So building on Kennedy's executive order, we can think about it as remedial. This is kind of backward-looking affirmative action. The idea here, according to the court, is that the government can use race to overcome the lingering effects of the government's own prior illegal discrimination. So, for example, if the city of Chicago could point to a place in its history where the city of Chicago intentionally discriminated by employment or government contracting against racial minority applicants, and there's a lingering effect of that discrimination today, then the city of Chicago could use race in an affirmative action program to overcome the lingering effects of that prior illegal discrimination. Now, it turns out that's really, really hard as a practical matter to do for a lot of reasons we could talk a long time about. But in theory, that sort of remedial, backwards-looking affirmative action is a thing. Now, the higher education affirmative action actually operates in some ways exactly the opposite way. Higher education affirmative action isn't designed to be backward looking, but the way I teach this to my students is it's actually forward looking, in that the goal of race-based affirmative action in higher education is diversity in the higher education classroom, a sort of future-looking goal. It's not designed to remedy past discrimination. It's designed to look toward the future.
Let me interrupt you for just one second, though. Isn't that a function of the decision in the Bakke case where Justice Powell, writing for a very split majority, said that race could be used as a factor among many not to address past wrongs, but for this interest of diversity. So isn't that where that comes from?
Yeah, that's exactly right. And that's a really good point. So this idea didn't just drop out of the sky. It was actually created by a person, and in this case, by a single person who wrote the controlling opinion on this issue in the Bakke case, going all the way back to 1978, as you said. And that stuck. And so that's the way we have viewed race-based affirmative action in higher education ever since that time. The court, as you suggested, has kind of ratified that approach at several milestones along the way, but that core approach has always been with us until this case this summer. Now, just a couple of things about that. So what the court tells us is that anytime the government labels people by race or discriminates by race, that the court is going to apply a test we call strict scrutiny in assessing the government action under the Equal Protection Clause. What that means is that the government action has to be narrowly tailored or necessary to achieve a compelling government interest. That's a super tight fit. The government discrimination can be the only way that the government can achieve this super important, compelling government interest. Now, from the Powell opinion in Bakke, the court has said diversity in higher education is a compelling government interest, or can be if a university chooses to take it up. In order to use race in the admissions process to be necessary to achieve that interest, the university has to use race in a kind of, think of it as kind of a pliable sort of way. So a university can't use quotas. The university can't assign points based on race. It can't do anything that rigid. It has to use race as one of many factors in a holistic assessment of each individual student that helps the school diversify along a lot of different dimensions. It's not just race, it's a lot of other stuff too. Now, this is important for a couple of reasons. First off, we often misunderstand and therefore mistalk about higher education affirmative action in remedial terms. But constitutionally speaking, it's never been a remedial program. It's always a forward-looking program to achieve diversity. And so remedial speak around higher education affirmative action has always been a kind of constitutional mismatch. There's overlap, to be sure.
Can you give an example of what you mean by remedial speak?
Exactly. So, for example, we sometimes hear critique of higher education affirmative action that says, well, why should Black people get an affirmative action benefit in higher education? They have equal opportunity to apply and get into higher education colleges and universities. It's not about equal opportunity. It's about achieving diversity on the back end in the future. And so that's just a mismatch. There's another mismatch here that we often hear in the common discourse about higher education affirmative action. Remember, I said that the use of race has to be one among many factors in this holistic assessment. What that tells us is what, Kate, you and I both know, but people outside of higher education might not, that when we admit students, we're not admitting them only based on GPA and standardized test scores. Those are two data points, but they're not all the data points. We're looking at a whole variety of different factors when we admit them. And so we often hear in the public discourse, well, why should such and such get a bump based on race and get admitted over, and here for listeners, I'm using air quotes, over more qualified white applicants? That talk just doesn't resonate with the equal protection doctrine before this summer. It's not more qualified because we're considering applicants in their totality, right? Saying more qualified assumes that GPA and standardized test scores are kind of the end-all be-all in qualification for higher education, but of course they're not, and the doctrine has never supported that. And so again, that's a kind of mismatch. And then one final point, when we talk about the court applying strict scrutiny to government race-based discrimination or government race-based labeling, that too, it turns out, is is a mismatch with affirmative action programs as they actually operate. These programs are holistic programs where race is one factor among many. And oftentimes, and this was true in both of the cases that went before the court this summer, race is just a wee bit factor that operates on the far, far edges for not a ton of applicants. In other words, it's really hard to figure out exactly how race contributes to an application decision for any individual or even any class of individuals at any particular university. And so what the court's doing is saying, the overwhelming weight of factors in an admissions decision are non-racial. But because of this wee bit potential use of race, we're going to apply this super rigid test called strict scrutiny and scrutinize the entire program and overturn it. And you're like, wait a second. What's right? And that's going to be true, even if the plaintiffs in the case can't show that they specifically were denied only because of race. The way the doctrine operates here really is head spinning, and itself, in my view, perpetuates institutionalized racism because it operates kind of unevenly between racial majorities and racial minorities, quite frankly.
Okay, well, so then if race as a factor is on the margins, not very many, then why does it matter that they've overturned it if it was not playing that big of a role?
Right. Fantastic question. So the answer is it's playing enough of a role that that the ruling is likely to lead to a precipitous decline in racial minority enrollment. And here it might be helpful let's think about it this way. In admissions decisions without race, right? Admissions decisions, like so many other institutions in our society, are rife with institutionalized racism. And what I mean by that is a kind of disadvantage for people of color that flies under the radar screen that we are largely unaware of in our day-to-day and requires a little bit of thinking and scratching beneath the surface to ferret out. Considering race at all in higher education can help mitigate the impacts of that hardwired racism. But if we take race as a factor out, then all we're left with is the hardwired racism. And so for a variety of complicated reasons, omitting race from the admissions decision, just given history in some of the states that have experimented with this, is likely to lead to a precipitous decline in racial minority enrollment.
Yeah, so in both California and Michigan, they have had years, although in California many more years than Michigan, of banning of race-based affirmative action in higher education admissions decisions. So can you just talk a little bit about the track record for supposedly race-neutral application procedures?
Sure. So in both instances, what schools saw, it's particularly true in California, what schools saw is exactly what I suggested, a dramatic decline in racial minority enrollment right out of the gate when state schools were no longer permitted to use race as part of the admissions process. Now, what schools did and what they're scrambling to do now is to find other ways to ensure racial diversity in higher education. And again, even as I say that, I just want to remind listeners that schools, even though they may theoretically be able to do this, they're not trying to implement a remedial program. What they're trying to do is create racial diversity in the higher education classroom because they know that racial diverse classrooms and racially diverse education are the best ways to prepare students to work in a racially diverse, actual, real world. And so that's their target. And what they're doing to achieve that is think of them as kind of proxies for race that will help schools diversify even without considering race. And so, for example, we could consider socioeconomic status, which unfortunately has a correlation with race in our society, or first generation-ness, of an applicant, right, which also correlates with race, or geography, which too often correlates with race in our society. So other so-called racially neutral factors that actually are close proxies for race. Now, the irony of this is that everybody knows what we're doing, right? But the Supreme Court has kind of forced us to consider race in a non-racial way. Now, the irony goes even deeper. Under equal protection doctrine, there's a possibility, a remote possibility, and I don't want to give affirmative action opponents any more ammunition, but there's a remote possibility that a school that's using a proxy like socioeconomic status for race in order to diversify itself could be subject to an equal protection challenge because again, everybody knows what we're doing. We're trying to diversify by race. And again, that objective is unconstitutional under the court's reasoning. And so schools are really in a kind of catch-22 here, trying to figure out what to do. They can't use race, but they could potentially be limited in using other factors in order to diversify. And so what do? That's the struggle that we're facing today.
Okay. Let's take another break. I'm Professor Floros, and you're listening to The Politics Classroom, a podcast of UIC Radio. Welcome back to The Politics Classroom, a podcast of UIC Radio. I'm Professor Floros, and my guest in the classroom today is UIC law professor Stephen Schwinn. Roberts specifically exempted U.S. military academies from this ruling, arguing, as the military academies did in amicus briefs, etc., that for national security reasons, we need to have a diverse officer corps, and therefore they needed to be able to discriminate based on race in order to have this diverse officer corps. So, first of all, if diversity is seen as a compelling interest for national security, how does that not also apply to the rest of society? And two, how is that at all consistent? Like, the government in its own military academies can discriminate, but Harvard, a private institution, cannot discriminate based on the amendment that says the government can't discriminate. I mean, that does not make sense to me either. Can you please help me to understand that?
Yeah, it's kind of bananas. So,
okay.
Whenever the government pulls out the national security card, think of it as a heavy thumb on the scale in favor of the government, whatever the government happens to be doing, if the case is in the courts. And the idea here is that judges don't like to second guess the judgment of the government on national security concerns because they don't see themselves as institutionally competent to do that. I think really
but
because
they can on everything else.
Oh yeah,
like the environment and all these other things. Yeah. So they're institutionally not capable of talking about national security, but climate change, yes, they are institutionally capable of.
Oh yeah, and bring on, social engineering and social justice, like that kind of stuff. And history, by the way, oh yeah, they're experts in all that. But no, not national security. And so the government bringing out the national security trump card is going to put that heavy thumb on the scale, to mix metaphors, and result in the footnote like we saw in Chief Justice Roberts' opinion, which again is just bananas, right? And Justice Brown, Ketanji Brown Jackson, calls him out on this, I think, in a really colorful way. Basically, what the court's saying is, look, it's okay to use race to ensure that we can put Black people on the battlefield and in the trenches and get them killed. But it's not okay that we can use race to put them in the boardroom, right? What is that about?
Yeah. Really? I mean,
Yeah.
and then, okay, so I also want to make the point that of the 9 justices on the Supreme Court, 4 of them went to Harvard, 4 of them went to Yale, 1 of them went to Notre Dame. But before Amy Coney Barrett was appointed to the court, everyone who had been appointed in the 21st century had gone to an Ivy school, which these are the very institutions. And one could argue that without having gone to Yale, Clarence Thomas might not have ended up on the Supreme Court, but a decision that he is part of and pushing will potentially close that path to other aspirants of color.
This is a real puzzle with Justice Thomas. If you listen to him talk and read some of his writings, he thinks he was done a wrong at Yale and through the affirmative action program that allowed him to go there and allowed him to advance in his career beyond Yale, by the way. What he says is that there's a stigma that attaches when we grant a benefit to people of color that disadvantages them. There's a kind of assumption that people of color are only at a place like Yale Law School because of the color of their skin. And that stigma harms them, which is yet another reason, according to this line of reasoning, to worry about racial labeling as opposed to racial outcomes. What he says is if we lived in a, kind of level playing field world where we weren't giving out benefits by race, that we would recognize that racial minorities are pulling themselves up by their own bootstraps and getting into Yale Law School on their own merits without consideration of race. And of course, that ignores the reality of the way these programs work. But aside from that, it also ignores that people of color are not going to get admitted to higher education institutions at the rate that they are if we don't consider race as part of a holistic package. And again, that's based on our lived experiences in California and Michigan. And so, in my mind, it's a real puzzle where he's coming from. Again, it's one of those things that I kind of understand the logic, but wow, do I think he's off base.
Yeah. Okay, I think you mentioned this earlier, but so Harvard is a private institution. Why is their admissions policy subject to judicial scrutiny when Harvard's actions are not a government's actions?
Yep, exactly. And so for listeners, it might be useful to understand that the Equal Protection Clause and the other rights in the 14th Amendment only apply against the states. The court ruled that a long time ago in interpreting the 14th Amendment and hung its hat on the idea that the amendment starts with words to the effect of no state shall deny these rights to people. What that means today is that the 14th Amendment as a technical matter doesn't apply to private institutions like Harvard Law School. And yet we know that private institutions are subject to anti-discrimination norms because we see it every day, right? And so what's going on here? The answer is the Civil Rights Act of 1964 applies anti-discrimination norms to private businesses, and Title VI applies to private colleges and universities in the same way that the Equal Protection Clause applies to public schools. And so, Kate, you had mentioned earlier in the talk that there were 2 schools with 2 different programs, but one decision. And the reason that the court can write one decision on both schools under 2 very different sources of law is that the court has said that Title VI operates the same way that the Equal Protection Clause does. It's statutory, not constitutional, but the analysis is exactly the same.
Okay. Let's look at expected impact of this decision. So first of all, does this ruling apply to all programs at all universities, just select universities, graduate programs, undergraduate programs? What is this blanket across everything? And does it matter, whether it's just selective or whatever?
Yeah, so the answer is yes, it applies across the board, whether an institution is public and therefore covered by the Equal Protection Clause, or private and therefore covered by Title VI because they receive federal funds. And by the way, everybody does. The ruling is going to apply. What schools do with that is going to depend on their situation. And so, for example, you and I teach at UIC. We are proud of our tradition of diversity at our school, and we have worked hard to achieve that. I suspect, although I don't know for sure, but suspect that for a school like UIC, we will have an easier time maintaining our diversity, or at least some level of diversity, when our admissions, if and when our admissions officers discontinue using race. And I say if or when because I actually don't know if they use race now. That's going to be very different for a lot of schools that really are going to struggle to maintain a racial minority population in the wake of these decisions. And they really are going to have to move aggressively to look at alternatives, as we talked about earlier, geography, socioeconomic status, the struggles a student has faced and overcome in their lifetime, factors like that are racially neutral in the sense that they conceivably apply to anybody of any race, but are likely to have a disparate benefit for people of color in the admissions process just because of the demographics in our country. And so that, again, that's kind of where I think schools are at this point, just sort of figuring that all out.
And so does this decision mean that the court rejects diversity as a legitimate interest anymore? A diverse class? Is that no longer a government interest?
That is such a fantastic question. And so we talked earlier about this strict scrutiny test, that the government use of race has to be necessary to achieve a compelling government interest. What the majority in the court ruled this summer is on both parts of that equation, the compelling government interest and the necessary means to achieve it. On both tests, the programs fail. Now, the part of the test that you're asking about is the compelling government interest. Is it still a compelling government interest to achieve diversity in higher education? In theory, yes. But what the court said is the schools in this case didn't have a determinate way of measuring that. Like, how do you know when you succeed doing that? How do you even know what diversity means, right? And it's complicated by the idea that you would have to define diversity in largely, if not exclusively, race-neutral terms, because again, remember, we're concerned about a colorblind constitution. And so if a school like UIC, where we teach, wanted to say, we have a compelling interest in diversity, we would have to drill down and figure out on a granular level, what does that mean in terms of the racial composition of our class? But it's at that point that our definition of diversity would go south, because at that point we're using racial labeling. And so how to achieve diversity is a really hard thing. Again, you've got to do it in race neutral ways in order to get there.
So I'm just thinking, so there are a lot of protected classes, right? Based on sex, based on race, based on religion, based on all these other things. So can we use religion as a marker to have a diverse class, like a religiously diverse class? Is that still, can we take that into account? Can we take gender into account? Can we take sexual orientation or gender identity into account? I mean, is the whole point of diversity is that you have people of varying identities, backgrounds, etc. But if race is the only one that you have to tiptoe around, that kind of undermines the very idea of diversity, right? If diversity has to be colorblind, then that only leaves diversity on these other measures, and what preferences them above race?
Great question. So the difference between the other classifications that you've mentioned is that the court has said when it assesses discrimination on those bases, it applies a lower level of scrutiny than strict scrutiny. That's just a fancy way of saying that the government has a little bit more wiggle room in discriminating by sex or gender or sexual identity, sexual orientation, than it does with regard to race. Rightly or wrongly, that's kind of where the doctrine is.
Okay, so they can't discriminate on race either positively or negatively, but they can discriminate positively or negatively on religion under certain circumstances.
Well, religion could potentially be a little bit different. I got to say, that's a question I hadn't considered before. But if a public school is discriminating by religion in its admissions program, that's going to get some scrutiny by the court. I don't know exactly how it's going to treat it. I don't have a case to cite on that.
Yeah.
But it's going to get some scrutiny by the court because under the free exercise clause, the court applies a form of strict scrutiny to religious discrimination in the same way that it applies strict scrutiny to race.
I thought that was only for Christians, though.
Yeah, but see, this is what's interesting because it like equal protection works every way, right? I'm a white guy and I get equal protection under the court's approach to equal protection just as much as sort of my black doppelganger would get equal protection under the court's approach to equal protection, right? The court hasn't quite been explicit that that religious discrimination has that sort of symmetrical kind of feature to it. And again, in the context of higher education, affirmative action, it's a good question. I don't know exactly what the court would do there. I mean, I think what it would have to say is that if there's religious discrimination in higher education, that necessarily inures to the disadvantage of somebody because the courts sees higher education admissions as a zero-sum game.
Right.
And therefore unconstitutional. I suspect.
Okay.
But with regard to sex and sexual identity, sexual orientation, those two, I don't know exactly what the court would do with those, but I do know that it would apply a lower level of scrutiny and give the schools a little bit more wiggle room in how they were considering those characteristics as part of the admissions process.
Interesting. Okay, what about legacy admissions? Isn't that just affirmative action for rich white people? Yeah. I mean, they're being, like, we don't have a lot of time, but, this whole idea of people being admitted based on merit without any kind of critical examination of how we define meritoriousness, right? But like legacy admissions are absolutely not based on merit, right? It's based on who your parents are. And that seems fundamentally discriminatory. And I know that the Justice Department has opened an investigation into poor Harvard. What? I can't believe I just said that. I'm cutting that out. Their legacy admissions. So how does a program that largely, not exclusively, but largely benefits white applicants because of their parentage, is that affected at all by this equal protection argument?
Great question. And, to legacy admissions, I'll add admissions based on large donations to a school or
right,
political influence, or, your parent called up the admissions officer and had a long conversation with them based on their, I don't know, job or whatever. I mean, all of those things are going to work to the advantage of white applicants over people of color. And that's why schools like Harvard. Oh, and by the way, I suspect that this probably operates more at elite institutions like Harvard, where they do have more active programs to bring in and benefit legacies, for example. But that's why these schools are scrambling to drop them. In the wake of this opinion, there's a recognition that those are in effect affirmative action programs for white people. And so as part of an effort to think ahead how schools are going to deal with the opinion this summer and ensure racial diversity in the classroom, a piece of that puzzle could be dropping legacy admissions, which lead to a disproportionate white classroom.
Okay. Okay, so I know that because of COVID, a lot of undergraduate programs have made exams like the SAT and the ACT optional, and that has reduced some of the barriers to students from lower socioeconomic groupings and students of color. Are law schools or medical schools considering getting rid of the MCAT and the LSAT, and are schools doing that?
I can't speak to medical schools, so I don't know what's going on in that world, but I do know that law schools are moving toward allowing students to submit GRE school scores in lieu of LSAT scores, which is going to open it up a little bit. But I don't know, I don't know if schools are dropping test scores altogether as part of the process. We just went through this with my son, who just went off to University of Iowa this fall, when he was applying around last year at this time. And I was actually pleasantly surprised to see the number of schools that were dropping a requirement for standardized tests. It seems to be almost a universal thing these days. But I don't know if that's happening at the law schools.
Yeah. I mean, because again, if you're going back to my comment about merit and what is meritorious, right? How you perform on one standardized test that now apparently ChatGPT can pass. What does that really predict your ability to succeed in law school?
Exactly. Yeah. And yeah, I think that's right.
Yeah. Okay. So is there anything else about affirmative action cases, this case in particular, that you wanted to say anything about before we wrap up?
I don't think so, except this. The court's idea of a colorblind equal protection clause sweeps broader than its affirmative action jurisprudence. We're seeing this manifest in a lot of different ways in the court's rulings. And yet there was an important voting rights case that came down this summer where there was racial discrimination on the part of the Alabama state legislature in drawing its legislative boundaries. And the court, to a lot of people's surprise, and I'll confess to my own surprise, upheld a lower court ruling that struck the racial gerrymandering. And so the court seems to be open to some racial discrimination claims based on a kind of, and I'm trying to use my words very carefully here, a kind of disparate impact theory where Black people are disadvantaged. But it's not at all clear to me that that's going to sweep outside of this very narrow context under the Voting Rights Act that came up in the Alabama case. And so anyway, my larger message is this race-blind constitution is more and more a part of our legal reality.
Okay, on that uplifting note, I'm going to say thank you very much, Professor Stephen Schwinn, for joining me in the politics classroom. I've really enjoyed our conversation.
Thanks, Kate. I have too. It's been a lot of fun.
Professor Stephen Schwinn is a professor of law at the University of Illinois Chicago School of Law. Thanks for joining me today in the Politics Classroom, a podcast of UIC Radio. If you like what you heard, please help me spread the word by rating and reviewing the show and sending an episode to a friend. As always, I need to expand my social media presence, but I am on Twitter and TikTok at Dr. Floros. I'm also on Instagram at POLSCLSRM. And I even have a YouTube channel at Professor Floros. Also, don't forget the podcast website at thepoliticsclassroom.org. This is Professor Floros. That's all I've got for this week. Class dismissed.